640 at KLIF. Does President Trump have a Twitter problem?
Well,
boy, there's an open-ended question.
I'll tell you. Yeah. Byron Henry is an expert on federal law. He is with Scheef and Stone in Dallas. Also named one of the best lawyers in Dallas by D Magazine for 2017. And he's joining us now. Good morning, Byron.
Good morning. Glad to be with you.
Thank you. So what are your views on the presidential tweets? I think most of us just think, boy, he could set off an international incident of unimaginable proportions. But what about the legal aspect of the things that he's tweeting?
Well, it's no secret that President Trump has defied a lot of political norms since he's taken office, and in a lot of ways, he defied norms in his campaign, and in some ways by winning. And a lot of it endears himself to a lot of supporters, and it's really a good way to connect with supporters and to kind of go around the media, who often filters the president's message. The problem is it takes on a whole other, it's another level of impact whenever you have legal cases and you're the president of the United States. And so, especially in a context with, for instance, the temporary travel ban, where the president's statements, both in the campaign and as president, are being used as sort of evidence against him in his legal case. So it's very difficult for attorneys to manage a case. I can tell you, as an attorney, you wouldn't want your client, president or not, to be tweeting about the court that's hearing the case, about the judges that are hearing the case, or about the actual case itself while the case is pending. So besides the fact that it's nice to have a president that likes to engage with the electorate with tweets, it's not at all good to have a president that likes to engage judges and others in tweets while a case is pending.
I know that phone records, cell phone records, and the like can be admitted in court as evidence, but how about tweets? I mean, this is such a new area. Can social media be presented as evidence in a case?
Well, certainly in traditional cases, setting aside the president just for a moment, social media is evidence like just about anything else, from phone calls or recordings of Facebook pages and whatnot, and it's used as evidence on a regular basis. I don't know if it got its start there, but it was a big deal in family law cases with respect to individuals that were filing for and getting divorces about their activities, what was going on before the marriage ended, and that's been going on for years now, and there's been a lot of seminars about the use of social media, but more recently, there's been a lot of seminars about the use of social media by attorneys and their clients with respect to big high-profile cases such as the president's, and we're seeing the next generation of social media as basically policy evidence, not just evidence in court, but evidence of the way congressmen and presidents view policy. And we've already started seeing some social media and whatnot in campaign ads, and so it's gone to another level, so to speak, with respect to the president's tweets.
Yes, you mentioned the president is trying to get to the people directly without the interference or filtering of the conventional media. As a matter of fact, the hyperbole has gotten so outrageous that we've already heard charges that this whole obstruction of justice accusation is bigger than Watergate, and that he's worse than Nixon was, and all of this stuff that we keep reading. Law professor and analyst Jonathan Turley wrote several weeks ago that it takes more than an inquiry to constitute obstruction or tampering, that you have to prove that there was some intent there, and to secure an unlawful benefit for a person or for somebody else. Where do you see this whole case going with this, with James Comey's testifying, and then today Sessions will be testifying?
Well, there's a couple issues there, and I basically agree with what Mr. Turley wrote in his discussion of obstruction of justice. A lot of people think obstruction of justice simply means when somebody has some kind of impact or effect on an investigation, and that's simply not the case. So the first thing is when it comes to the actual elements needed to prove obstruction of justice, assuming the president can even be charged with that when it comes to dealing with his own FBI, that's the first problem. But the second problem is the president is the head of the FBI. There's kind of an unwritten rule in Washington and other political norm that the FBI is somehow independent and not subject to the president's either inquiries or impact of something he says or his orders, but that's simply not true. The president is the head of the FBI, and the FBI director works for the president. He's appointed by the president, as you can see by his power to fire former Director Comey for no reason. He can fire the FBI director for cause or no cause. And so he's allowed. It's legal for him to inquire about investigations. It's even technically legal for him to direct investigations, though most presidents consider that politically radioactive, so they try to avoid it and allow the FBI director and the FBI to go about their business in independent investigations. But in the end, the president has the absolute authority to both interfere with and interact with the FBI director about ongoing investigations, even if that's a political no-no in Washington. Legally, it's simply not prohibited. So I don't think there's a lot in the end to the obstruction charge, but certainly President Trump is flirting once again, as I said, pushing the bounds of what's considered acceptable in Washington, D.C., and he has a lot more to worry about the legal problems. He's got political issues. He has to deal with Congress and the American people with respect to his approval and attempting to get his agenda passed. So you've got to consider those things as well as the legal impact.
All right, Byron Henry, an attorney with Scheef and Stone. You can find him at solidcounsel.com.